Depending on where you all are joining from, I'll say good morning, good afternoon, or good evening. This is Enherad Lang speaking. I'm the Executive Director of PHAP, which is short for the International Association of Professionals in Humanitarian Assistance and Protection. Very pleased to be serving once again as your host for this 21st in our series of online learning sessions in our track on humanitarian law and policy. I see many people joining us today from all around the world, a lot of familiar names and some new participants, so a warm welcome to all of you. Just to highlight, we have really an extraordinary diversity of perspectives, I think today in the room, geographic perspectives in the list of top 10 countries of registrants. We have Switzerland, the US, UK, Syria, Iraq, Turkey, DRC, Nigeria, Jordan, and South Sudan, and I see so many other countries as well, people hailing from in the chat. Please do continue to introduce yourselves, of course, so we can all see how many people are joining today from around the world. So as you know, we're looking today at the topic of legal protection of internally displaced persons, IDPs, and given the, as we'll see, unprecedented number of people fleeing their homes without leaving their country of origin, both in conflict and disaster contexts, it's really crucial for all humanitarian actors to understand the existing legal protection of IDPs under different legal frameworks, and we'll be looking at different legal frameworks today at international, regional, and to some extent national levels. Okay, so having said all this, we'll move on to the substance of today's session. Just I'll begin with a few brief thoughts, and then I'll introduce our speakers. So although the causes can be similar or the same for refugees and internal displacement, the two groups are, as I think probably most of you know, protected under different legal regimes. For international refugee law to apply, an individual has to have crossed an international border. Therefore, IDPs, internally displaced persons, by definition are not protected by refugee law. However, IDPs are protected by other bodies of law, and we'll be learning a bit more about that with a presentation from Jean-François in the first part of our session today. The presentation from Jean-François will be followed by a presentation by Cecilia. Cecilia Jimenez is the newly appointed Special Rapporteur on the human rights of IDPs, and she'll be focusing her presentation on the current challenges that she faces with her new mandate and her priorities for the protection of IDPs. Now, as we saw in the beginning, this is a subject generally that most of you are familiar with to some extent, and also most of you are actually directly engaged with in your work. So we have people coming in at different levels. I'll quickly go over the general learning objectives for the overall session that we've identified. So first of all, we'll be looking at the different legal frameworks, as I mentioned, relating to the protection of IDPs, including international human rights law and international humanitarian law. We'll be looking at states' legal obligations towards IDPs and the limitations of those obligations, and we'll be looking at current challenges in applying the legal frameworks in practice. We'll begin by briefly setting the scene. Now, for those of you who are less familiar with the extent of the problem of internal displacement, so we have a few slides here to help illustrate the extent of the problem. By 2015, as you can see, more than 37 million people were displaced within their national borders, with a particularly high concentration in Colombia, in the Middle East region, Horn of Africa region, Sudan, and DRC. Also important to observe on the next slide, thanks, that conflict and violence has played a very significant role in those regions, causing an enormous degree of internal displacement over time, and importantly that the effects persist over a long period of time. So you can see, for instance, Colombia remains the country with the highest number of IDPs, although there were relatively few new displacements in 2016, so demonstrating the often protracted situation of IDPs. I'll also highlight that there's an increasing number of IDPs or internal displacement caused by weather-related disasters, and that this figure is, of course, expected to increase in the future along with the exacerbation of climate change effects. And finally, of course, worth noting the trends over time. There are far more people internally displaced now than at any other time since 1990, as you can see on the slide, and that furthermore, the relative proportion of refugees and IDPs has shifted. So we now see the number of IDPs globally is more than double the number of refugees, and this disproportion has not always been the case. So we're seeing some important trends and very dramatic trends in terms of the scale and nature of the problem. Okay, so now moving to introduce our speakers more officially, if I may. I'll begin with Jean-François Durieux. Jean-François has had a 30-year career with UNHCR, during which he served in Africa, Asia, North America, and Latin America, and in headquarters positions. His last role in UNHCR was that of Director in the Division of Program Support and Management. He's taught international law at the Refugee Studies Center at Oxford. He was also the director of the International Refugee Law and Migration Law Program at the International Institute of Humanitarian Law in San Remo. And he's currently contributing both as a module convener and as a tutor to the distance program in Refugee Protection and Forced Migration Studies of the University of London under the auspices of the Refugee Law Initiative. And we're very pleased to have Jean-François back with us today. I'll mention at the end a previous online session that he's done with us that may be of interest to many of you on the subject of refugee law. We're also really delighted to have with us today Cecilia Jimenez, who assumed her new role as the UN Special Rapporteur on the Human Rights of IDPs just recently in November 2016. She's a human rights lawyer specialized in forced displacement and migration. She has over 2 decades of experience in NGO human rights advocacy in the Asia-Pacific region, and also has teaching experience as an adjunct professor of IHRL, that's International Human Rights Law and International Humanitarian Law. She was previously with the Internal Displacement Monitoring Center, the IDMC, here in Geneva, and as the National Director of the IDP project of the Commission on Human Rights of the Philippines, and more recently was the government representative to the Philippine Transitional Justice and Reconciliation Commission. And then finally, in my introduction, I'm most proud to say that both Jean-François and Cecilia have been members of the association, members of PHAP, both for several years. So very happy to have both of them with us here for this exciting event. Now, without further ado, I will give the floor to Jean-François for his presentation to help start things off here.
Good. Thank you very much, Anne-Hared, and good morning, afternoon, evening to all of you there. I'm quite impressed by the numbers. If you were in the same room here, I would have no space to breathe. So excellent. I really look forward to this conversation. I titled this A Quick Introduction to the Law of Internal Displacement, and believe me, it's going to be quick. It's going to be super quick, but I hope that at least we can assert some of the basics. Because it has to be quick, let me see if I can move to the next slide. Okay, good. Thank you, Marcus. Okay, I'll keep it simple. So basically in this session on the law of internal displacement, we'll try to answer 4 questions. Who is an internally displaced person? Why is international law concerned with internal displacement? What does the law say? And how does it work? Okay, good. So let's start with the who. First of all, the notion of displaced person. I think it's clear to all that displacement implies an element of coercion. This is why internal displacement is part of this concept of forced migration. Many people move within the boundaries of their own countries for all sorts of reasons. Displaced, of course, implies something very special. Internal, we know what it means. It means within the boundaries of one state. In the vast majority of cases, IDPs will be citizens of that state. But we can also have people who are not nationals of the state, but that move within the border of one state, and that remains internal displacement. Comparison with refugees and refugee laws abound, of course, here, and indeed there is a lot of similarity between the two situations. But of course, the fact that refugees are foreigners, whereas IDPs are mostly citizens in their own country, that makes, of course, at international law, a world of difference. As with refugees, when we look at who is an internally displaced person in law, we will see that both the causes of displacement and the consequences of displacement are relevant to this definition. So there is actually an international definition of an IDP. There hasn't always been. And here really the groundbreaking moment was in 1998 when the guiding principles on internal displacement were issued. I'll come back to the guiding principles in a minute. Here I'll stick to the definition that it gives, which, by the way, is also found in many national laws and also in the Kampala Convention, which I'll also mention later on. So the elements of the definition, beyond the fact that people are still within the borders of one state, is that we are talking about people who are forced or obliged to flee or to leave their homes. There is a nuance between forced and obliged. There are people who move because they have no choice. But the no choice may mean that either somebody is, basically putting a gun on their head and asking them to move, while others, of course, do not wait for this to happen and they move in a more preemptive manner. In both cases, they are forced or obliged to flee or leave their homes. Now, the definition includes a number of causes, and this, for those of you who are familiar with the refugee definition, you will see some similarities and differences. Here, for example, the word persecution does not appear as such. However, it is probably subsumed under the other terms that appear in the definition. Because the definition of the guiding principles refer to several causes: armed conflict, generalized violence, human rights violations, natural or human-made disasters. You know that the refugee definition does not include people who are displaced by natural disasters, so that's already one important difference. But I also draw your attention to the fact that it says in particular as a result or in order to avoid the effects of. So this list is actually not limitative. These are just examples, and they're supposed to describe situations where the displaced are in situations of particular vulnerability. Good. Why is international law concerned with internal displacement? Nowadays, maybe this question looks a bit silly. You are all there working in the field, probably many of you with an international organization and concerned clearly with the protection of IDPs. But that has not always been the case. I think that the figure of an IDP and the issue of internal displacement is relatively new as an issue that international law deals with. The international community and international law have been rather slow to wake up to the issue of internal displacement. Why is that? Well, it is because, again, we're talking about citizens displaced within their own countries. And states, of course, have been resisting what they would resent as undue interference with their internal affairs and say, well, this is actually an internal problem if it is an internal displacement. So things have changed, which is really good. But let's bear in mind that the international dimension is, of course, not immediately apparent. Refugees are an international issue by definition because they involve two states at a minimum. The real reason why international law is concerned with internal displacement is because, despite the fact that it happens within the boundaries of one state, it is a human rights issue. And human rights violations, whether they cause displacement or they affect IDPs, cannot remain hidden. So the standards and the mechanism of human rights law are to be put at the service of IDPs as particularly vulnerable citizens within their own countries. It is also a humanitarian issue, of course, and here I think that we can take humanitarian in two meanings. One is IHL may actually apply, international humanitarian law, the laws of war, because many IDPs find themselves in situations of armed conflict where IHL applies. We'll look at some of these rules later on. It is also a broader humanitarian issues, even in situations that are not qualified as armed conflict, because there is a humanitarian imperative to save lives and to protect people who are put in a particularly vulnerable situation. Again, here, the IDP movement that over the last 2-3 decades has actually put IDPs on the forefront of international attention, has also, I think, a responsibility, a very positive responsibility in promoting such things as responsible sovereignty, the responsibility to protect, etc. Moving on, let's now look at the contents, well, first the sources and then the contents of the law. As I said, international human rights law would apply because it applies in all circumstances, of course, with the limitations that may be present in the various instruments. And similarly, international humanitarian law will apply in conflict situations. Many IDPs find themselves still engulfed in conflict. They may be under the control of one of the belligerents. They may actually be disputed as populations by the belligerents. So their international humanitarian law would obviously come into play. And with a link with international criminal law, you know that international criminal law may be a means of enforcing standards of international humanitarian law as well as human rights law. And in the context of displacement, for example, ethnic cleansing is actually identified as a crime against humanity in the Rome Statute of the ICC, of the International Criminal Court. But these are, of course, the broad and non-specific framework that apply to IDPs because they are human beings and sometimes caught in conflict. Then we have more specific instruments. The first one, chronologically, is indeed the famous 1998 Guiding Principles on Internal Displacement. Here we're talking about an instrument. It's not a treaty. It is actually a non-binding set of guiding principles. They've been welcomed by the Commission of Human Rights at the time, by the General Assembly, by the World Summit of World Leaders in 2001. That gave them, of course, a standard and a standing and an authority. The guiding principles have influenced domestic legislation on IDPs in many countries, and they also have had a direct influence on the one regional treaty that exists. So we don't have a universal treaty on IDPs, but there is at least one piece of regional law, which is really important because it covers potentially all African states that are members of the African Union. This is the Kampala Convention that was adopted in 2009 and currently has 22 member states in Africa. It entered into force in 2012. These are the sources. Importantly, let's take a look at the law behind the guiding principles. The guiding principles have not invented an IDP law. They have actually made essentially a compilation of existing norms of international law, essentially human rights law and IHL, as they apply to internally displaced persons. The guiding principles, by the way, is a very good document. It's very easy to read. It's very powerful. And of course, that is for one basic reason. It has not been negotiated, unlike a treaty, right? But as I said, it is a great source of inspiration. The structure of most of the principles contained in the Guiding Principles document reflects the fact that these are not new norms, these are mostly existing norms, so they must reflect and be consistent with what already exists at international law. So we will see a couple of examples later on, and you will see that the principles start by stating the generally applicable rights, saying, for example, every human being has a right to life, and of course that will include IDPs, and then in a second breath address the special protection need of IDPs in relation to that right. Also important to bear in mind that because they're not a treaty, the guiding principles can actually have a broader audience. Nobody's signing up to them, if you wish, but they are addressed not only to states, but also to other authorities, which of course will mean, among others, armed non-state actors who may control IDP populations, also addressed to the UN, to other international organizations, and to non-governmental organizations. Three main blocks in the guiding principle, but also, for example, in the Kampala Convention. And here, no surprise, this actually represents the famous cycle of displacement. So the first block of norms concerns the prevention of displacement or the prohibition of displacement. The second, protection during displacement. And finally, the concept of solution, which will be familiar to those of you who have been working also with refugees. Displacement is wrong to start with. It has to be brought to an end. It has to be solved. So we'll follow that structure in the few slides that come now. On prevention, basically from a human rights perspective, displacement is actually an issue of a possible violation of your freedom of movement. Because the freedom to move, but also freedom to reside in a place of choice. And the Human Rights Committee, already in 1999, has made it very clear that the right to reside in a place of one's choice includes protection against all forms of forced internal displacement. In fact, when we look at displacement as a human rights problem, we see that it affects a bundle of rights. You can look at it from the freedom of movement, as we just did. But you can, and some courts have also looked at it from the perspective of other equally important rights that are violated in the process of displacement. Respect for private life, land tenure, crucially important, of course, for indigenous populations, but also for others. Right to property, because when you're displaced, you have to leave your home and therefore your properties. Adequate housing for the same reason. So it's again, this is to show that human rights law provides several points of entry into the issue of internal displacement. The guiding principle number 5 to 9 talk about prevention by establishing the prohibition of arbitrary displacement. Now, this is actually a new notion, if you wish, but again, it is derived from existing standards. We see, for example, that displacement is arbitrary and therefore prohibited, right? Whoever does it, when it is based on policies of apartheid, ethnic cleansing, the like, when it is used as a collective punishment, or when, and this is important, when the duration exceeds what is required and justified by the circumstances. Displacement is also prohibited by international humanitarian law within an armed conflict context. Here, the language talks to ordering the displacement, right? Ordering, so it means a direct action by one of the belligerents to actually displace the population. And this is prohibited by the second additional protocol, for example, in the context of non-international armed conflict, unless the movement of people is required by the security of the civilians or by imperative military reasons. We have no time to enter into what imperative military reasons mean. As you can imagine, this is open to all sorts of interpretation, but for those of you who know IHL well, you will know that there is actually some jurisprudence that restricts this exception. Large-scale development projects also cause displacement. And in fact, the movement, the displacement of population is prohibited also in those projects unless, again, public interest is compelling and overriding. In natural disasters, same thing. Displacement, of course, can be helpful. It may be required for health or safety of the populations, but otherwise it would be prohibited. Good. Let's move now to the second block, which is protection. So here we're talking about people who are already displaced. The displacement may be wrong in the first place from a legal point of view or not, but the fact is that displacement has created a number of protection needs, of vulnerabilities that need to be addressed. And here, generally, I would say that there are two principles that you will find through the guiding principles and through the Kampala Convention. That is, of course, to address the particular vulnerabilities of IDPs, but also to remedy the discriminatory consequences of displacement. And there are two possible sources or types of discrimination here. The guiding principles make it clear that you cannot discriminate between IDPs and the rest of the population. They are all civilians, they're all citizens, therefore they cannot be discriminated against on the basis of their displacement. That would be an adverse distinction. That would be discrimination. And it's also prohibited to discriminate between IDPs, because you may have IDPs from different ethnic groups, from different religions, from different places in the country, and of course you cannot discriminate between those. So this is really what these standards aim to do. I'll give you two examples, and for the rest, I really advise you all to, if you haven't done it yet, to read the guiding principles, and for those of you working in Africa, the Kampala Convention too. There's a lot of overlap between the two. Of course, it talks about a huge number of rights that need to be protected, a great number of vulnerabilities. I'll give you two examples so that you see a bit how it works, what is the structure, and also what is implicit in these protections. And as I said, I have to say the guiding principles are actually a very, very, very good piece of law. It is very precise, it is very well put, and it is actually consistent with existing international law. So if we look at Principle 12, for example, it talks about the right to liberty and security of the person, which is your right not to be arbitrarily arrested or detained. Again, this is, first, you have to reaffirm it for all. So it's not because you displace that you lose this right, or that you cannot exercise this right. And then the second paragraph explains what it means to give effect to this right for IDPs in particular. And it refers to something that many of you are familiar with, which is the concept of a camp. Many IDPs, like many refugees, unfortunately, actually live in camps. And in fact, this principle basically establishes that because of the existence of the right to liberty and security of the person, IDPs should not be confined to a camp. And when in exceptional circumstances, that confinement is absolutely necessary, it shall not last longer than required by the circumstances. Good? So it shows you how it works. And then if you look at the third paragraph, again, it has a non-discrimination clause. Another example would be Principle 20, which is the right to recognition everywhere as a person before the law. Every human being has that right, but it is a fact that when people move involuntarily, they lose not only probably their home and many of their possessions, they also lose their papers. They therefore risk losing their identity. And of course, this is completely unacceptable, especially considering that they're citizens within their own country. And therefore, again, we have a second paragraph that explains how you give effect to this right for IDPs. It says the authorities concerned, and here it's interesting because they're not necessarily state authorities. You may actually here have a responsibility for non-state entities if they actually control territories, and therefore they are relevant authorities. They shall issue to them all documents necessary for the enjoyment and exercise of their legal rights. And here there is actually a bit of a tension. That in some places, IDPs don't want to be identified as IDPs. because it's like a stigma. It's like a label that is put on their forehead saying this is an IDP, therefore probably an enemy or something, you know, causing problems, etc. And therefore, if you look well at this article, it doesn't say that you have to give to IDPs papers that say IDP. It says you have to give them papers that enable them to exercise their rights as citizens, right? So in some places, and we may look at some examples later on, it is actually advantageous to have an IDP status. But what is certain for all is that it's absolutely essential to be properly documented, birth certificates, ID card, because this is what enables you to exercise your rights as a citizen. And then we have a gender and age consideration coming in the third paragraph, which is just based on the reality, the experience that in many situations, women and children actually have less access to documentation than men. And of course, this is also unacceptable. Good. Third block, solutions. As I said, displacement is an exceptional situation. As we have seen, sometimes it's actually a wrong that has to be righted. So solutions may actually be, for example, to bring the IDPs back to their homes as soon as the military necessity has ended. But in all cases, this displacement, which may last years, as we all know, has to come to an end. The big difference, of course, with the refugee approach, if you wish, is that refugees, by definition, are in a foreign country. So what matters to them as the ideal solution is that they're able, in safety and with dignity, to return to their country. Here we're talking about people who are already within their own country. It means that not all of them will want to return to their homes. Their homes may have been destroyed, and in any case, they have the right to settle anywhere in their country. And therefore, here, return in safety and with dignity remains an imperative, and that must be facilitated by all authorities to the largest extent possible, but not, of course, against the will of the people. Some other IDPs will actually choose to resettle within the country, either in the place where they've been displaced or in another place. And in all these cases, states and, where applicable, other authorities have a duty to facilitate their reintegration. An important principle which is affirmed in the guiding principles and in the Kampala Convention is the participation of IDPs in the planning and management of their return or resettlement. Okay. Good. In the Kampala Convention, I just noted here a few provisions. As I said, there is a fair amount of consistency of overlap between the guiding principles that are non-binding and the Kampala Convention, which is a binding treaty. On durable solutions in particular, there's an obligation which is made by states, by treaty, to establish conditions and to provide means to allow IDPs either to return voluntarily to their homes or to resettle again voluntarily in another part of the country. The Kampala Convention also includes an obligation to provide effective remedies, fair compensations, or other forms of reparation to IDPs for their losses. This is significant because if you look at the 1951 Convention on Refugees, for example, you will see absolutely zero reference to compensation or reparation. So we have here a very important principle of human rights that is affirmed in the context of internal displacement. Good. Finally, how? How does the law work? Well, that question, of course, is valid for international law in general. For human rights law, we know that what mechanisms exist. Some of you have followed other online or face-to-face training offered by PHAP, and therefore you know also how IHL works. I would suggest that IDP law is not terribly original in this context, right? For example, look at the Kampala Convention. You will not find a supervision mechanism within the convention. You will not find a treaty monitoring body. you will not find the reference to a specific international organization. It doesn't mean, however, that the law doesn't work or that it has no teeth. The principle remains that, of course, the primary responsibility for the protection of IDPs and for facilitating solutions lies with the state of nationality. And here we can look at the advantages of having a national legislation. We all know that international law often works best through its domestication, through the fact that it exists on the book at the national level, and therefore you can have resort to the judiciary and other national mechanisms. A fair number of countries have actually a national law on IDPs: Angola, Kenya, Sudan, Georgia, Bosnia-Herzegovina, Ukraine, Russia, Colombia, Peru, Chiapas. I'm reading here. Don't believe I know this by heart. Other countries, other states have what they call a policy on IDPs, which is not exactly a law, but at least it is a legal, a national framework. Not the case, for example, of Uganda, the Republic of Congo, Burundi, and others. So, advantage of a national legislation, yes. Does that law need to give a specific status under national law? I already alluded to that before. In some cases, it is advantageous because there are special benefits that are attached to for example, an IDP registry. In other cases, it will be more advantageous to the IDPs not to be labeled as IDPs, but to be enabled to exercise their rights as citizens. Responsibilities of non-state armed actors. Here, of course, we're talking about situations of armed conflict. Yes, indeed, the non-state armed actors, to the extent that they can actually displace population, or they can actually control displaced populations, they have also a responsibility that are not different from the responsibilities of states as belligerents. However, I note here that the Kampala Convention, because it's been adopted by states, reproduces a rather traditional approach that actually criminalizes non-state armed actors, looks at them mainly as agents of displacement, as wrongdoers, and not as duty bearers or sometimes as protectors. For example, the Kampala Convention says that non-state armed actors have no right to infiltrate IDP settlements. Interestingly, states have the right to infiltrate settlements in a situation of conflict, but the other side doesn't. The whole concept of infiltration, of course, is rather vague. As we know, many IDPs actually have sympathies for some of the non-state actors, and therefore to talk about infiltration is probably a misnomer. But this is, of course, a treaty that has been adopted by states. We should not be surprised. Finally, there is no dedicated international organization. You don't have a UNHCR for IDPs, and I believe there will never be. However, importantly, there is a special rapporteur on the human rights of IDPs, and we're lucky that she's with us today. So that, of course, is a very powerful mechanism for the protection of IDPs and for bringing attention to this continuing problem. And then there is a protection role of the humanitarian community. Here, I speak probably, to many of you who are actually part of these humanitarian communities in countries where you have displaced populations. The protection role of an NGO or an international organization that provides water or sanitation or health in a situation of displacement cannot, of course, be the equivalent of the protection role of a treaty monitoring body or of a special rapporteur. But it is an important role. And the concept of protection mainstreaming, I suppose, is now known to all of you. You probably have in the country where you work something like a protection working group, a protection cluster. It means that protection remains an important activity of humanitarian workers in situations of internal displacement. It does not give them necessarily the standing that they need to openly oppose, for example, wrong government policies affecting IDPs, but it certainly helps to ensure daily protection for the displaced populations. I think I've probably exceeded my time, but I've been as quick as I possibly can. So thank you very much for your attention, and I'm sure that there will be interesting questions. Thank you very much.
Thank you very much, Jean-François. An excellent presentation. And indeed, we have a tremendous number of questions coming in. Excellent questions. I've noted down 3 that I think perhaps it would be interesting to go straight to them as questions for some clarification now. And then we'll move into the presentation from Cecilia. And then at the end, hopefully we'll have time for additional questions and a discussion between both of you. But first, for clarification, so first we had a question, and perhaps Jean-François, I'll simply read the 3, and then you can take note and respond as you wish. So first, a question from George, who's asking simply, what about the role of customary international law with regard to protection of IDPs? Is that an important aspect of the protection regime? We also had a question coming from Justine in the Q&A and also echoed by both Ahmed and Bodinga in the chat about how is it defined for how long the circumstances require IDPs to be confined in camps. So essentially, so is there a definition in place so that we can say now the time has been extended? Is there a time limit? How is it defined when the circumstances require IDPs to be confined in camps? And then finally, a question from Christina. This is a bit of a technical one, but maybe of interest to others. What happens with refugees who become internally displaced in a situation of armed conflict? And she's thinking specifically about Palestinian refugees who are in Syria and then became displaced within Syria. Do they still fall under the refugee definition? Of course, it may be a special case with Palestinians, but I'll leave that with you.
Thank you all for all your questions, and thank you, Anne-Harriet, for selecting these 3 that are so tough. I'll try my best. George, customary international law, yes, obviously. I mean, it will also apply. I cannot think of any standard that is specific to IDPs that would be part of international customary law. But obviously, every piece of customary international law that you can find in IHL, and there's plenty, and also in human rights law, would indeed be applicable. And then, as you know, customary international law may indeed matter in the absence of a treaty, meaning because, of course, every state would be bound by these rules. So in that sense, they are important. But again, nothing specific really on IDPs as part of customary international law. To Justine and others, a very good question. You know, how long is the time absolutely necessary, which I think is the terminology used in the guiding principle that I showed you on freedom of movement and arbitrary detention, and basically it's not actually a prohibition of a camp, but it is certainly an affirmation that camp should not be the rule and the exception. I think that this is how you should approach it, not least in your advocacy work. So no, of course, the law does not say how long it is. I don't know. I don't think there is any domestic legislation that actually puts some sort of a deadline on the establishment of a camp. So this is something that needs to be assessed. And I think that really what matters is, if you want to take this article seriously, is actually to try and negotiate at least this, that there is a regular assessment of the continuing need for this confinement. And then there should also be at all times information given to the IDPs that they actually have the right to leave the camp. Now, this may be contrary to national policy. In that case, that needs to be negotiated with the authorities, but that is clearly what the principle says, right? So the refugees will be the IDPs will be the ultimate judges of, for example, the safety that they can find in a camp or the services they can find in a camp. There may be very good reasons why they want to stay there. There may be very good reasons why it is still unsafe for them to leave, but they should be offered the opportunity to leave at all times as citizens. Finally, refugees becoming IDPs. That is actually a very good question, and I'll be actually interested in hearing also Cecilia on this, because I have to say this is a debate I've had several times with her predecessor, Professor Shaloka Bayani. In my view, of course, refugees who become displaced within their country of asylum remain refugees. That is very clear. They don't lose their refugee status because they are subsequently displaced. But they should also, because of the displacement, they should also benefit from any provision that exists to address their vulnerabilities as displaced. So indeed, you can be at the same time a refugee and an IDP. In the same vein, you can be at the same time a former refugee, a returnee to your own country, and an IDP. This has happened to many Afghans, for example, who repatriated voluntarily, thinking that the situation would be okay in their country, and they could not actually remain or stay in their places of origin. They had to move again and join the ranks of Afghan IDPs. And there are specific provisions and programs for returnees, and these people indeed probably should benefit from both those as returnees and as IDPs.
Excellent. Thank you very much, Jean-François. And we had we had about 15 more questions come in as you were speaking, but with regret, we'll have to see if we have more time at the end, and then to find ways to follow up afterwards. So there's clearly a lot of interest to continue the discussion. But now it's with a great pleasure I would like to introduce once again Cecilia Jimenez, several years PHAP member, and now, of course, recently appointed Special Rapporteur on the human rights of IDPs, has been a speaker in several of our courses in the past. Cecilia, it's great to have you on the line. How's your connection working? I'll just...
Yes, hello.
Yes. Oh,
I'm
hello.
Brad.
Yes, excellent. It sounds fantastic. So, Cecilia, I will give the floor over to you, and we look forward to your presentation.
Thank you very much, and I would like to give my greetings to everybody who's on the course right now. It's really a pleasure, and as Angarad says, it's good morning, good afternoon, or good evening. I do see a lot of people who are on this course outside of the normal office hours, so that gives us also some inspiration. So thank you again to PHAP, which I consider really part of my family whenever I have to do humanitarian and human rights work on internally displaced persons. And the purpose of the presentation I have and have been asked to make is really to provide and to disclose, explain what my strategic approach and priorities would be for the next 3 years. As Angarad had mentioned, I took up the position November 1, 2016. It's been a whirlwind since, and considering that, being Special Rapporteur of the United Nations is actually supposed to be only a part-time position. So, and that by itself is already challenging. So thank you, Jean-François, for giving so much emphasis on the fact that there is a Special Rapporteur on the human rights of IDPs and sort of comparing it to the UNHCR. I'm afraid I will not even be able to really reach a level of what the UNHCR does. What the UN Special Rapporteur does as a mechanism or as an entity is really two things, two very important things. One is to be a watchdog of the situations of internal displacement persons all over the world, and this is very important, to be able to advocate on the protection of the human rights of IDPs. So with this slide that I have for the very first topic, the slogan, if you want, that I would like to apply for the first 3 years of my mandate is actually what I would call visibility and action. And here you have a picture actually of some IDPs. This is from Philippines, where I am from. But these IDPs are not what we would be calling normal IDPs. These IDPs are actually nomadic people on the sea who actually had to flee from their particular places of origin. So just to begin with, the mandate has been established by the UN Rights Commission way back, and later on this UN Special Rapporteur position became a special, was actually very first of all the special representative of the Secretary General, and later came back to being Special Rapporteur. Right now, it's governed by the resolution that was passed in 2016 by the UN Human Rights Council, to which I report, and this is a resolution that is adopted every 2 years. So in 2018, there will be a new resolution on the mandate of the human rights of IDPs that will be the subject of negotiations among states. Renewal of the mandate itself, though, is every 3 years, and this is why this is the term. Now, what is really essential in understanding what the mandate is all about is that the mandate is focused on human rights of IDPs with the guiding principles as a basis. I thank Jean-François for explaining so very well what the guiding principles is all about, because that is actually very fundamental on concerning the norms that I am supposed to be working with. The continued engagement of the mandate is also with states, actually, is based on the principle that states have primary responsibility to promote and protect the human rights of IDPs. This primary responsibility is, as we may all know, based on the principle of sovereignty, which is very sacred in the United Nations, with states being members of this big body. And with sovereignty, there is that primary responsibility. As Jean-François has explained very well, when we say IDPs, these are people within the borders of a particular state, have not crossed an internationally recognized border, and so that means that states will have to be not only responsible but accountable for the treatment of IDPs within that border. The resolution also provides that the mandate is supposed to promote mainstreaming of the human rights of IDPs into the UN system. I'll talk a little bit more later about that, but that remains to be one of the very important tasks that a mandate holder has to undertake. Fostering dialogue with states on the promotion of human rights of IDPs in countries is as well a very important task, and this is also one reason that the Special Rapporteur is supposed to be, upon invitation of particular states, supposed to be visiting those states with IDP populations in my case. And the official visits of a rapporteur is a very important tool, if you want, not only in order to access the reality of the IDP situation, but also to provide means and opportunities for the mandate holder to enter precisely in this dialogue with the states. Naturally, when the mandate conducts its country visits, the mandate holder would naturally also be talking and interacting with the IDPs as well as the NGOs working on the protection of IDPs in that country. Last but not the least, and this is really a very big task that is provided to the mandate, is the analysis of the causes of internal displacement, and through this analysis providing and assisting states and other organizations through the recommendations of the mandate, raise awareness, as well as mobilization of support. And this means that all these tasks are supposed to be done by one person. For me, it's an impossible task completely. However, I think what is important for the mandate is to be very strategic as to what it can do and cannot do, considering that it's only a one-person mandate. But I am very fortunate at the same time that I have a staff in Geneva, and as well other organizations like the UNHCR and OHCHR, of course, that provide very needed support. The take-off point of the mandate is human rights of IDPs. This is very obvious from the title of the mandate. I'm not going to go through this because Jean-François has done a magnificent job in doing so, but suffice it to say that the human rights of IDPs are provided very explicitly at the international, regional, and as well as policy frameworks. And just one line about policy frameworks: these may not be law, but however, these can provide guidance in the work that humanitarians and human rights stakeholders are doing to protect IDPs. For example, the Interagency Standing Committee Framework on Durable Solutions. It also produced a gender mainstream guide, and we have international policies such as the 2030 Agenda for Sustainable Development, which I would like to use in order to promote the human rights of IDPs. But at the bottom are the human rights of IDPs. Levels of partnerships would be, of course, at international, regional, and national levels. We have states. I have traditional partners at the international and operational levels. For example, the humanitarian agencies, particularly UN High Commissioner for Human Rights, the Office, the OCHA for the coordination, and through the Interagency Standing Committee. International NGOs have also been very, very key to the success of the mandate. And right now, because of the developing discourse on the treatment of IDPs, emerging partners for the mandate are the UN Development Program, the UNDP, as well as the International Organization for Migration. I would like, in the also part of the next 3 years, to place an emphasis on an emerging partnership with national civil society organizations, including IDP associations. For me, as a person who came from the national level and as a person from the field, it is very important for me as a new mandate holder to ensure that the local voices of civil society organizations are always brought into the equation. Now, I would like to approach my next 3 years with what I call a strategic approach with impact. First of all, by making IDP and internal displacement issues more visible in international policy for the purpose of concerted commitment and action. And secondly, to enable the strengthening of international and response to IDP rights and internal displacement based on the guiding principles, and very important, very significant, with a view to durable solutions. I added durable solutions to this strict approach precisely because we would like to have IDPs return to normal lives. It is naturally incredible for me that there are double the number of IDPs compared to refugees, for example. And really, in terms of the responsibility and accountability for that, I would like to approach many states with this view that durable solutions have to be achieved for these IDPs eventually, if not sooner. Continuing attention. Of course, I actually inherit this mandate from very prestigious predecessors. First, it was Professor Deng, who is what I would call the grandfather of the guiding principles, and it was under his tutelage and guidance that we have the guiding principles. He was followed by Professor Walter Kellin from Switzerland, who again made the mandate operational, and last but not the least, Professor Chaloka Biani, and all of these people I respect very much, and them being academics, they have been very, very helpful to the international community and to many states and NGOs as to how protection should be provided, undertaken, and definitely through human rights. It is therefore my actually pleasure that this of course, this protection through human rights as a task will be having my continued attention, and this will be also a very much a foundation in most of the work of the mandate. Durable solutions, I did mention this already a while ago. My predecessor, particularly Professor Chaloka Biani, has raised this to be an important issue in the implementation of his mandate. I will continue to place a big emphasis on durable solutions precisely because internally displaced persons do deserve the right to have normal lives like you and me. And the best way to do this is, of course, for them to be able to attain durable solutions. Continuing attention, again, is law and policy. This is the third issue that I will give continuing attention to. Kampala Convention was very much a focus in policy under Professor Chaloka Biani, as well as other regional policy frameworks. One thing that Jean-François has mentioned, which I agree very much, is actually the promotion and establishment of national IDP laws or policy. And this I'm very keen to do because also of my own field experience in helping countries go through the processes. And I have a flagship course, by the way, and this is the Sanremo annual course on internally displaced persons law and policy. This is hosted every year by the Institute for IHL in Sanremo, and with the support of partners like the UN High Commissioner for Refugees, and as well as the Office of the High Commissioner for Human Rights. This flagship is very important to the mandate because it gathers together mostly government authorities that are in charge of IDP law and policy. I'm very sure that Jean-François knows this from his stint in the IIHL in Sanremo. The analysis of all causes of displacement is, of course, part and parcel of my task, but I would like to add at this point in time that because of the preponderance of displacement due to development projects, I have personally and professionally an interest also in this, and I have worked in a good number of situations where IDPs caused by development projects have been the focus of my attention. So the analysis of all causes of displacement will, of course, be part and parcel of my mandate, but for anybody who is interested in development-induced displacement, I would be very happy to hear from you on this because I would like to develop this further. Now, being a new Special Rapporteur, obviously each person who occupies a mandate has very, very specific experience. I am not an academic, but I do consider myself to be a field practitioner. And one of the items or the issues that I place a high value on is the participation of the internally displaced persons themselves in processes and decision-making that concern them. This is essential if we will be having the protection of human rights of IDPs as well as durable solutions to be directly relevant to the IDPs themselves. You will see on this slide on the left are actually a gathering of indigenous peoples who are talking about their internal displacement situation. And again, we know indigenous peoples in many countries are also most of them become IDPs, and I could say that it's not only because of conflict, but also because of development projects, be it particularly the extractive mining industries. The picture on the right is actually an IDP manifestation, an IDP rally in the Philippines when they were being asked to relocate by the local government, and they said no. And I thought that this is a very interesting um, organized activity that the IDPs themselves um, gave attention to, because the IDPs have to have really an involvement in any decision making that concerns them, including relocation, if this will be one of the solutions provided by government. Another emerging thematic approach is my own professional interest in peace negotiations, peace processes, and transitional justice. This has been part and parcel again of my background, and I have worked in a good number of situations where we have transitional justice and reconciliation, peace processes and conflict transformation, and peace building. Interestingly, although these issues, these themes have already been brought up here and there, but there has not been a consolidated attention of the mandate on these issues. We know very well that many IDPs are IDPs because of conflict, and one way of really addressing the root causes of that displacement would be through going through a peace building process that could hopefully perhaps result into transitional justice and reconciliation as well. Another emerging thematic approach are IDP kids. My predecessors have had specific thematic reports on women, for example, but not yet on IDP children. And IDP children for me encompasses really what could be wrong in the treatment of the in protect human rights of IDPs, because once you see an IDP kid who is not protected by the law or by humanitarian approaches, then for me that is really one of the bottom situations that one can actually encounter in the field. So this would be one of the thematic reports that I will be doing, and I'm thinking of doing this thematic report sometime in 2018. Last but not the least is, of course, the role of different national institutions, including National Human Rights Institution. As Angarad mentioned, I had worked with the Commission on Human Rights of the Philippines in directing the IDP project that had been supported by the UN High Commissioner for Refugees. And so I have direct experience in this. I also having also been a trainer, trained the Uganda Human Rights Commission, for example, as well as the Ombudsman in Yemen. This was before DOR exploded. I think, I do believe that national human rights institutions have a very potential role in delivering, guaranteeing, raising protection of the human rights of IDPs within their particular country. At the moment, I'm actually in Doha, in Qatar, having just finished participating in an international conference on human rights approaches to conflict in this region. There were many human rights institutions here, NHRIs, and even representatives of the different networks from Asia, from Africa, from Latin America, and because they're here, this means also that they're, of course, very interested in looking at human rights approaches to conflict, and naturally IDPs is one of the issues that we looked at. So there is a big potential here, and again, I will be looking at this. Hopefully I'll have a report on NHRIs, the role in IDP protection, if not in 2018, then most probably in 2019. So one of the tools that I mentioned earlier on is that aside from the general advocacy, from having the thematic reports, and participating, of course, in policy making, in law and policy making, country visits is a very specific tool that is provided to rapporteurs, to mandates like me, and for me right now, the reflections that I have is that mandate can bring IDP protection through my monitoring as technical assistance and bringing out positive practices and sharing lessons learned. I have a wish list of countries that I would like to visit, which at this point in time I'm not on a liberty to reveal, but rest assured that these are countries where there have been grave situations of internal displacement, and as well have not been visited by the mandate. At the same time, initially, these IDP situations be due to conflict, generalized violence, and natural disasters / climate change. And meanwhile, my predecessors have visited many countries, and I do intend to follow up to those countries in terms of monitoring the recommendations made by my predecessors, for example, on Nigeria, on Ukraine, and Georgia, etc. The value of collaboration for me is essential. And I have been very lucky to have the political support of many states for the resolution of the mandate. At the same time, operationally, international humanitarian and development agencies are very, very helpful to me. And I would also like to bring out one agency, and it's actually a service, and this is the Joint Interagency Profiling Service that had been set up by international agencies, mainly in Geneva. And I'm very happy to collaborate with them because I think JIPS is a very good example of how collaboration, effective collaboration, can be undertaken. And last but not the least, of course, are NGOs, CSOs, and where possible, IDP associations and organizations. Last but not the least is my collaboration through the Interagency Standing Committee. I have been very fortunate that the architecture actually provides that, because one of my tasks is mainstreaming human rights of IDPs into the UN, I have been given a seat as a principal of the Interagency Standing Committee, and I have been able to attend my very first meeting last December in Geneva. That's me with the red scarf, so you can see my face. And here, I think it's a very good opportunity to provide influence to the United Nations and other agencies about IDP protection. So success for the mandate for me is actually impact on the ground, in the promotion of human rights of IDPs at policy and operational levels, at various strategic international fora, and at state levels. So this would be, for me, success would mean, and hopefully that at the end of my 3 years, I would have attained some confidence that those indicators of success would have been achieved. Thank you very much.
And thank you very much, Cecilia. Great to hear from you, and thanks so much for sharing with us your reflections and your vision, your priorities, particularly at this point early in your tenure. It's great to hear from you on this, so thanks so much for taking the time. We have a number of questions that have come in, and I see we do have a bit of time. I'll pose, if I may, a couple of questions to you now, and then we'll see where we stand in terms of time. First, a question that has essentially actually come in twice. So from Amal, based in France, and then also from Fernando, based in the US, asking essentially what are the opportunities that you see, if any, for your priorities as Special Rapporteur to be integrated into the Global Compact for Migration. So that's one question. And then we had another question coming from Doris, Doris Nerere, asking, could you potentially benefit in your position from collaboration with other special procedure mandate holders, in particular right to food, right to health, and right to adequate housing? So I'll leave those with you. Cecilia?
Okay, thank you very much, Angarad, and thank you very much also for the those questions. Yes, I saw those questions about the opportunities at the international level, and particularly bringing up the issue of the Global Compact. Now, on this particular issue, as we know, there was an attempt to try to attempt last September in New York to put IDPs alongside refugees and migrants, and that did not actually succeed. I would first of all would like to have a thorough understanding, a thorough discussion as to why it did not succeed, and then we can talk about the Global Compact. Now, the Global Compact at the moment is, of course, again, focused on people on the move, and I think it could be a very good opportunity to raise the IDP issue. However, I do have a caveat. Can we actually also try to think what would be actually the added value, what would be the added value of having IDPs in the Global Compact? Because would this be the most appropriate forum, most appropriate summit and declaration, or should we be thinking about something that could really be about IDPs? These are questions actually that I still have no answer to, and also maybe at this point in time, just looking at the timing continuum, maybe we can also look at the Guiding Principles 20th anniversary, which is going to be in 2018. It will be 20 years soon that we have the UN the guiding principles on internal displacement, and would that probably be the more appropriate timing so that we can look at the particularities of the vulnerability and protection needs and rights of IDPs, which could be very, very different from those of refugees and migrants. As I said, I have no answers yet, but these are the challenges, and I would like to actually have people think through that, and your particular feedback would be very important to me on this. Collaboration with other special rapporteurs within the special procedure mechanisms system of the UN, definitely, and in fact I have already started doing that. One of the very first activities that I entered into, that I took on, is actually an invitation by the Special Rapporteur on transitional justice, Pablo de Grief, who had asked me to join an Asia Pacific workshop. And naturally in this one I raised the IDP situation. The other one is in collaboration with the Special Rapporteur on the Rights of Minorities, where I assisted the rapporteur in the drafting. I provided some language for the drafting of her recommendations for minorities in humanitarian and conflict situations. And I also gave an intervention particularly on durable solutions required by minorities. So I am very open. Collaboration is an operational word for me, not just rhetorical. I'm very open to having a dynamic collaboration with my fellow special rapporteurs.
Excellent, thank you. Another question that I see coming from a number of people, I'll paraphrase, but several participants, Abdul Fattah, Alex, and others, are asking, so with reference to the Kampala Convention, wondering, would you see, and this may be, of course, further down the line, but would you forecast at some point a similar development of a regional convention in other areas of the world? So our participants are noting in the Middle East region, in Colombia, still such a significant problem in terms of international displacement. Would you see, predict some movement towards additional conventions?
I wish I can predict what's going to happen in the world, but with regard to the regional framework, I have to say, first of all, that each region is very different. And what's funny about the region that I come from, Asia Pacific, is that it's actually 5 different regions altogether, and any regional framework that will come out of any of the regions of the world, be it Latin America, it could only be Central America, for example, or Southeast Asia, will really have to be a framework, be it a policy or a treaty or even just a declaration, why not, that has to really connect with the realities of that particular region. I have to say that the Kampala Convention is very precious in that regard, because it gave us an example of what can be done at the regional level. Mind you, the Kampala Convention still has to be ratified. It's been ratified by a good number of countries already, but we do still need to do to have more countries. Kampala Convention will hopefully have its first ever Conference of States Parties this year, so I will be attending that. And the value, as I said, of the Kampala Convention is that it is a very, very good example, but it may not be what it should be in other regions. And yes, I will be working with some of the regional organizations like the OAS and the Inter-American system, because they are actually, for example, interested on having something on IDPs at the regional level. We now already have the San Jose Declaration. I think that's a very good start. So bit by bit, and with the support of states, and of course the continued advocacy of human rights NGOs and humanitarian NGOs, I think we can do this as at the regional level, but my caveat is that it has to be really have an impact on the ground.
Okay, great. Thanks so much, Cecilia. And I wish that we could continue with so many more questions. We have a lot of people asking specific questions about where you plan to visit and what some of the specific strategies might be that you could pursue, particularly around making governments more accountable for protecting IDPs. I think, unfortunately, we don't have enough time now in this session to really go on further in this regard, but I would love to give you the floor, Cecilia, one more time to give some closing remarks, and as well to Jean-François. So let's perhaps first turn to you, Cecilia, for some closing thoughts, if you'd like to leave us with some parting ideas, and then hopefully we'll have the opportunity to do something like this again soon, so we can keep the conversation going. So over to you, Cecilia.
Thank you. I would be very happy to do something again like this, and probably also have more interaction with the participants. So thank you very much for your attention and frankly the interest that's generated by this online course is very inspiring to me. But I would like to leave one particular thought in the implementation of the mandate. And this is an implementation of the mandate that comes from the bottom as much as possible. Of course, we are using international law, we're using international norms. That is inevitable in any international undertaking, like the protection of the human rights of IDPs. But for me, in order that the mandate becomes really accepted and owned, then there has to be really an engagement at the national level, if not at the local level. And this, for me, would be the visibility and action that I would like to aim for, really the protection with, from the bottom. Thank you.
Thank you so much, Cecilia. I really appreciate, again, your being able to take the time, and wish you all the best with your mandate. And now to Jean-François, I'll give you the floor for some parting thoughts and perhaps to preview something we have planned for later this year.
Yes, thank you. Thank you all, frankly. Well, thank you, Cecilia. And I was trying to follow both your presentation and the chat. That's actually difficult, but just a sign of my old age. But anyways, I can see from the chat that we actually have a large number of real experts online. So that's really exciting to see how you also engage with each other. What I want to say is a couple of things. One is that this is the end of the session, but it should not be the end of the conversation. So please don't hesitate to repeat your questions if it has not been attended, to create new questions and send them on. And definitely from my side, I'll try my best to answer, not immediately, but within a very short time of receiving the questions, because I think that this is, if there are any areas of doubt on the law or even on the practice, I don't think that we should leave those gray areas there. We should try to dispel any doubt. So that is definitely a commitment on my side, and I'm sure also from Cecilia and of course the colleagues here at PHAP. The second is that I would like to say that if any of you out there have experience in discussing matters of IDPs or prohibition of displacement with armed non-state actors, I'm particularly interested. It's an area where there is less practice, less experience, of course, than in dealing with states for obvious reasons. And I'm currently working on a project that actually tries to fill that gap. So your contributions to that, your own experience, if you have any, or just questions on this particular topic of the role of non-state actors, especially armed non-state actors in the protection of IDPs, would be truly welcome. And finally, yes, to say that, of course, this has been a rush session. I think it was a privilege to have Cecilia with us because it gave a very different perspective to have not just a dry presentation of the law, but also to have somebody representing a powerful mechanism, a one-person powerful mechanism of implementation. I think it's a good formula. I think that we should continue to do that, but it was very short. But we are working here at PHAP on a longer course, probably a 3-day thing, focusing on the law and practice of forced displacement, that is refugees as well as IDPs. We haven't set a date yet, but it's going to be in the month of September. So if you are interested, and it's going to be in Geneva to start with, and hopefully we'll replicate that in other parts. But this will be our pilot. So if there is an interest, just stay tuned and follow the news on the PHAP website. You'll be informed in due course. It will be fun, of course, to see you face to face after reading your questions and your comments. Thank you very much to all.
Terrific. Thank you very much, Jean-François. And yes, absolutely hope to meet many of you in person later this year. So do stay tuned for more news on those plans, which are rapidly developing. So with that, we will call this to a close. Once again, thank Cecilia Jimenez and Jean-François Durieux for being with us today for their excellent presentations, and to all of you, most importantly, as active participants in the discussion, the riveting chat. It's been really great to have the chance to interact with all of you. We look forward to having you back again sometime very soon in another online session, or indeed on-site course or workshop. So as we wrap up now, just a few final housekeeping notes. The recordings, this has been mentioned in the chat, those will be available in the coming days at the URL you see on the screen there in front of you, and we'll send a follow-up email with that link as well, together with the resources that have been mentioned and posted in the chat throughout the session. As promised, I did also want to share with you the link to a previous session that we did also with Jean-François, making a presentation on the legal protection of refugees. Also a great session, very informative, and you can access that recording at the link you see there. We can also include that in the email follow-up that took place in October of last year. So with that, thank you once again, and a good morning, good afternoon, and good evening to all of you. Great to have you with us, and we look forward to welcoming you back again soon. This is Gerard Lang and the team from PHAP signing off from Geneva.